Hi everyone, welcome back to my channel. Today we're going to be looking at the latest motions filed by Mark Means in the Lori Vallow Chad Daybell case. Mark Means is one of the attorneys for Lori Vallow, and he's filed some rather interesting motions. This filing came across my radar, and if you would like a former paralegal's hot take on this, then stay tuned. That's what you're going to get, a former paralegal's very frustrated hot take on this filing. And if you want to learn a little something, let's go ahead and do that while we're looking at this mess. In this district, they go ahead and put what we call the attorney block at the very tippity tops. In my jurisdiction, the attorney block would be the last thing in your filing. And then you have what's known as the style of the case. And then you have the motions. And here you see the declared motions. So looking at this at the top, you see the filing information. At the top left, you see the attorney block. Then you see the style of the case. You see that the district that the case is in. And then you'd see the motions at issue. This is how someone looks at this with a legal eye. Now, in my opinion, we're going to go into the twilight zone. We have a declared motion regarding the state to disclose Brady violations disclosures. Then we have a motion for criminal depositions. Then we have a motion for out-of-state subpoenas. And then we have a motion to disqualify the Idaho Department of Health and Welfare. And keep in mind that when you file these kind of motions as an attorney, you're swearing to these things. You're affirming these things to the best of your knowledge. So with that in mind, having so many what I would call conspiracy theories over a span of time makes me question things, makes me doubt the veracity of what is being filed. That's just my opinion. And this is the part of the motion that's called a pleading. And the concept is that the movement is coming before the court and pleading to the courts. That's why it's called a pleading. And the defendant is asking for these motions and any further relief as discovered through the motions. And now we have an explanation about how on June 8th, 2021, the court here entered an order of commitment regarding Lori Vallow, and that she was further committed to the custody and the control of the Idaho Department of Health and Welfare. Also, this is put as an attachment to the pleadings. So then it is sworn and affirmed that he met with Ms. Daybell on October 15th, 2021 in person, and that during a discussion with her, it was brought to Mark Means' attention of unethical and possible illegal activities, discussions, disclosures, and manipulation of the incompetent defendant. Mark Means swears and affirms that before his meeting with his client, Lori Vallow, the defendant, that she was being treated by the IDHW. And this person is identified as NC. So on or about October 5th, 2021 of this year, the clinician NC and Lori were engaged in, quote unquote, watching the transfer of the trial motion regarding the defendant, Chad Daybell. And as an aside, while I do have legal experience, I don't have any mental health treatment evaluation experience. So I don't know whether this is ethical or unethical on the front of when she's getting mental health evaluation treatment. One would think that if she's in a facility that's trying to make her mentally well in order to participate in her defense, that it wouldn't be unheard of to have her watch her own proceedings or the proceedings having to do with Chad Daybell. One would think that that wouldn't be crazy, but I personally do not know. So allegedly, while Lori's watching this hearing for her co-defendant Chad Daybell, she was recommended to contact the LDS Church, the legal counsel, to discuss her own case and to possibly obtain legal counsel to assist her. Right out of the box, this makes no sense to me. You have a patient that's in a mental health facility that they're trying to make her well in order to be able to participate in the defense of her own trial. And let's say she shows interest in watching her co-defendant on TV in a live hearing, and she watches the said hearing. I don't understand that a clinician would give her homework, so to speak, in order to call to get another attorney unless she was vehemently saying that she wanted a new attorney. I don't understand that anyone would overstep that or even think to do that unless she offered it, but that's just my opinion. And it's always important to read the sassy footnotes. And Mark Means puts, "It is abundantly clear that the improper disclosures and communications between the defendant and NC have been made that are in violation of defendant's due process rights and irrelevant to her treatment while in control and custody of IDHW." When someone is deemed incompetent to stand trial, what is their due process right to reach out and try to get a different attorney? He goes on to swear and affirm that NC took the recommendation, air quotes, further and then provided Lori Vallow with the direct telephone number to contact LDS Church Council and issued a quote-unquote order that this was part of the defendant's homework for her treatment. If this is accurate, on its face, this would be unethical towards the treatment center because Lori Vallow has counsel and she's been deemed incompetent. He alleges that this clinician checked in with Lori Vallow to ensure the assignment was completed, and that NC allegedly told Lori Vallow it was quote-unquote a good idea to call LDS Corporation, and that Lori Vallow would not have done this on her own without prodding of the staff, the employee, and that Lori Vallow repeatedly said she didn't want to call the LDS Corporation, but for the homework, she would not have done it. He then asserts that the defendant, Lori Vallow, was forced and or manipulated by those in positions of authority and control of her incarceration. And my question immediately out of the gate is, do you believe this incompetent defendant? Not only do you have to believe that what she's saying is true, then you also have to believe that what Mark Means is affirming is what he thinks is true. And then you have to look at the court record and see if he's done any other what could be called quote unquote frivolous filings. And in my opinion, he has made frivolous filings against the state. And in my opinion, this could be a frivolous filing against the Idaho Department of Health and Welfare. And even if it is a valid filing against the Department of Health and Welfare, to then reach your hand out and say, oh, and also the state's in on this is, to me, a humongous reach. They would not want to screw up their case with something this silly. That's my opinion. So then he says that this mandatory homework was assigned to Lori Vallow and the LDS telephone number was given to her, and that then she proceeded to call the LDS headquarters in Salt Lake City, Utah, and that then she spoke with a female receptionist and asked to speak with the LDS church legal counsel, and that the receptionist asked, of course, as you always do, who it is on the phone, and that she disclosed who she was and that she was seeking legal assistance with her criminal case, and that she disclosed her name as Lori Vallow Daybell, and that she was transferred to an attorney believed to be one of the counsel for LDS Church, Mr. Daniel S. McConkle. And note in the footnote, it says right here, it is unknown whether this attorney is currently employed directly with the LDS Church Corporation or is one of the many legal counsel for said corporation. Mr. McConkey is believed to be only licensed in the state of Utah. So does he work for them or not? I mean, be clear about that, right? Now, it seems to me that it's true that Lori must have called this fellow while she's being helped for her mental issues at a state facility. Now, does she have privileges to call whomever she wants? Perhaps she does. We don't know that. One of the top 3 challenges for an attorney is to get the client to follow your advice. And I'm sure it's particularly problematic if the client is deemed incompetent. While we want to protect the client from themselves, sometimes we can't. Sometimes they go off the reservation, so to speak, and do whatever the heck they want to do. The question here will be whether Lori was allegedly pushed to do this, to reach outside her protected zone, and whether she did so at the urging of somebody else, and whether there were fail-safes in place in order to keep her protected. And that's what will be looked at here. But to put this on Rob Wood is just folly. So according to this motion, Lori Vallow reaches out to Mr. McConkey. and she gives him her name, and that she proceeds to make Brady violation disclosures under the guise, the thinking in her mind that the church was her friend and there to not only assist her with her legal matters, but her spiritual matters. So you would have two layers of protection. You'd have a legal protection between attorney-client privilege. You'd also have the religious protection. Okay, so that's what he's claiming here. And that he also says that the other attorney bragged about his 30 plus years of criminal litigation as a prosecutor, and that he told Ms. Vallow that he knew already every detail of her case, and that this discussion between Miss Lori Vallow and Mr. McConkey led her to make further disclosures that she wouldn't have made if he hadn't said those things. Okay, so why is this in front of Rob Wood, right? Well, in my opinion, this is in front of Rob Wood, not because he did something wrong, but because the client, Lori Vallow, broke her privilege. She has a privileged bubble with Mark Means and any other attorney that's assigned for her death penalty case. And in order to get her well, she can say whatever she wants inside of this privileged bubble, and the privilege is not broken. But if she goes out of her own accord and breaks the privilege, then all of a sudden things can become known. And the problem is that Mark Means is saying that she was pushed to move outside her bubble and that she isn't well. So this is a problem if true, but the problem is do we believe what Lori Vallow has to say about it? Is she a good witness for herself? And as I'm reading this with you, I would think that the first answer to this would be to get the deposition of this NC character from the Idaho Department of Health and Welfare and see what they have to say about it. Any attorney worth their salt getting a call from a patient at the Idaho Department of Health and Welfare that's vetted through the receptionist, that knows it's a high-profile case and that person is represented by the attorney, any attorney worth their salt would kick that right back to the attorney to make sure that that was kosher before he spoke with that client. That's in my opinion. That attorney, this fellow, should have further vetted this person. That's in my opinion. Now, again, we're taking the word of Mrs. Vallow, and Mark Means is also taking the word directly of Mrs. Vallow. We have to vet this. The footnote says it is unknown whether this attorney is currently employed directly with the LDS Church Corporation or is one of the many legal counsel for said corporation. So is he employed there or not? Mr. McConkey is believed to be only licensed in the state of Utah and was aware that defendant was incarcerated at the time of the telephone call. This motion goes on to allege that Mr. McConkey, as legal counsel for LDS, never advised Lori Vallow of possible conflicts of interest, that he was also not licensed in Idaho to practice law, that there was possible Brady violations, that there was an impossibility of him to represent Lori Vallow in Idaho for a criminal matter, or that his conversation with her would not be protected by attorney-client privilege. What a darn mess, right? Now, we're talking about the LDS legal department, right? You wouldn't have a receptionist that just came from the streets, would you? You would have a receptionist that knows how to properly vet a phone call and to take a message. Then you would have an attorney that would take a call and know a tiny bit about the person that they were talking to and to be able to figure out what state they're in and whether you would even be able to represent them. So this is a very strange conversation. If he did engage in this conversation with her, it's odd to me that he wouldn't recognize that there could be a conflict of interest and that he would need to immediately kick this back to Mark Means and whoever else is representing her. This is extremely concerning to me, and that makes me doubt the veracity of it. But then by that same token, she obviously had a conversation with this fellow. And so what really happened here? And if this is true, and if this happened as the defendant claims, this is a prime example of why attorneys need to take ethics classes. I mean, you should have the receptionist get back on the phone with her and ask her if she has counsel, and that to have the counsel contact each other. You don't take this client's call, but then again, I'm not in Idaho. He alleges that Lori Vallow described the attorney as eager to discuss her case, and only after certain disclosures were made by the defendant, so apparently she kept talking Allegedly, that the attorney then told her he would assist her with finding an attorney that could legally practice law in Idaho and possibly provide her assistance with their matters. So then he did give the stopgap. He did stop and say, hey, wait a second here. I can't represent you. Let me get you someone who can. So that Mr. McCorkle then said he would get back to her. So then he did put her on hold, huh? So reading between the lines, Lori Vallow seemingly ran her mouth before the attorney could tell her he was not going to represent her. The motion goes on to say that the attorney was going to get back to her, but instead the attorney called Mr. Wood to discuss the matter and the conversation and to tell him the statements that Lori had made. So this makes sense. She's reaching out from her protected bubble. She gets a hold of the LDS attorney. He listens to her talk for a while. Then he says, oh, stop. Let me get back to you. Then he realizes, hello, this isn't correct. So he calls or contacts Rob Wood, and then he relays what Lori Vallow has said. So Lori Vallow seemingly has broken her own privilege, but I suppose that Mark Means, as her attorney, is saying she was sort of hoodwinked, my words, into doing so. She was hoodwinked into breaking her privilege. So one wonders what the heck she told this attorney. Did Lori Vallow, under duress of some kind, then tell someone outside of her privilege bubble something that inculpates her that was privileged? And then that person goes and tells Rob Wood, the state, as agent of the state, something against the defendant that is bad for her. So I'm reading this with you guys as I'm doing this. So then after the conversation between Mr. Wood and the attorney, Mr. Wood then calls the main attorney for Lori Vallow to tell him about the conversation. And I ask you this question: why is this motion being filed by Mark Means and not by her main attorney? That is my question. Why is Mark Means so insistent to file this and not her main attorney? I'm really confused, because he, in my opinion, is the one that's filed what's, in my opinion, frivolous motions before. And why didn't her other attorney, Mr. Archibald, also sign this jointly with Mr. Means? Can we hush it up? Can we unring the bell? Can we make the state not know it? Can we hide it? Can we cover it up? Can we find out what she said? Call it a Brady violation, which it truly isn't Brady, by the way, but that's just my opinion. Yeah, now I understand where he's digging with this. So let's continue with this motion. Allegedly, after the conversation between Mr. McCorkle and Lori Vallow then turned to this NC person and told her that she had made the phone call, and that NC allegedly said back, good. And that Lori Vallow then relayed to NC at a later time that she had told her legal counsel, Mr. Means, of the encouragement to call, the call, and the conversation, and that the NC then replied, no, you didn't. The motion goes on to state, quote, again, defendant has a publicly well-documented obsession with the LDS Church and her controlling belief of its divine origins and truth in religious matters. So is Mark Means saying that his client's obsession with the LDS Church is overriding her ability to follow her attorney's instructions? And if so, in my opinion, whose fault is that, and whose ability is it to keep her constrained within her protective bubble? Did anyone do anything unethical here? That's the question, right? And here's where we leap into the conspiracy theory, in my opinion. It says, this imbalance and or unrealistic belief of Lori Vallow appears to have been purposefully used against her to engage or act against her own self-interest and without supervision of her attorney, Mark Means. So he's implying that, knowing that she has this obsession, that someone has used it against her to make her act against her own self-interest. If so, who is that? Is that the state here? Is that the Idaho Department of Health and Welfare? He continues, this behavior by those with power and authority over Lori Vallow are believed to have engaged in unethical, legal, and psychological rules of ethics, possible illegal actions and or violations that drastically affect the due process rights of the defendant. These behaviors are, as they appear, abhorrent and blatant manipulation of the incompetent defendant. Furthermore, the LDS Church has embedded itself into this case by way of its public statement dated, it's an attachment, on August 4th, 2021. I think it's 2020, isn't it? But anyway, and has incentives to disavow connection between the defendant and its church corporation. The statement of, quote, "I know all the details of your case" by an attorney with 30 plus years of experience to an incompetent defendant with LDS ties plays on the defendant's self-evident irrationality and belief in LDS Church corporation doctrine and leaders. Oh boy, that's a mouthful, eh? If she just got the number and called, how was this attorney gonna know ahead of time? How was that a conspiracy? He didn't know she was gonna call. Seemingly, on behalf of his client, Means is coming for the Department of Health and Welfare. He's coming for the LDS Church and their attorney's behavior here. You have to be able to cure a problem. If someone causes a problem, you have to put that problem in the proper court and be able to cure it or fix it. In this case, so far, as I've read, doesn't seem like Rob Wood did anything wrong. He was just the recipient of some information and then immediately notified the parties of the problem. Did someone at the institution where she is being held actually put something in her head and give her a phone number to make an outside call, which resulted in her breaking her attorney-client privilege with everybody with the knowledge that she's unwell? I mean, that's why she's there. Honestly, I wouldn't put it past someone doing something hinky in this case, because people are strange and strange things have been happening. This case is extremely strange. But by that same token, I have a hard time believing that every stop in the road people are making errors, that the attorney that talked to her sat there and chin wagged with her and to a certain point and then heard admissions from her of some kind that would step on a Brady violation, which makes me laugh, because isn't that where the state has something exculpatory or inculpatory and fails to turn it over? I mean, here, Rob Wood obviously called them right away and said, hey, this is what she's doing. Get your client under control. I understand he's making a record of this, but in a way, it's making a conspiracy maybe where one doesn't exist. Surely the prosecutor's office aren't in league with the Department of Health and Welfare. And we haven't got to the prayer yet. The prayer usually is where you ask the court for what you want. I mean, what is he going to want? Her kicked out of the Department of Health and Welfare? I mean, where's she going to go? I swear this case is the wackiest thing ever. Let's get back to this nonsense. He says it's strange credulity to ignore the facts that the LDS Church Corporation and its legal counsel are probably involved and or working with the state prosecution, oh Lord have mercy, to manipulate the defendant to be forced and manipulated into statements against her interest. No, actually, it's strange credulity to believe that, in my opinion. And what I say to that is prove it. Prove it to me. Let's see. A detailed and exhaustive investigation into this matter is a must for the defendant's rights and to expose nefarious activities of persons elected and or appointed to pursue justice, not manipulate an incompetent defendant into submission. Oh Lord, really? So here's a motion for the state to disclose communications, including but not limited to Brady violations. Fine. If there's anything that she told the state, turn it over. If it's reduced to text, recordings, telephone, whatever, turn it over. That's fine. Let's get to the bottom of this. This is shenanigans. What else you asking for here? Okay, a motion for the criminal depositions and out-of-state subpoenas. Okay, so let's see. Criminal depositions because you want to imply whatever was done was criminal. And out-of-state subpoenas because the people involved that she called were out of the state. So, okay, so now you want this court to reach with its long arm statute to do this? Okay, honestly, he could do a little of this legwork himself since he's coming forth with this conspiracy theory, but that's just my opinion. What else he asking for? Let's see. 3, motion to disqualify Idaho Department of Health and Welfare. Okay, Really? Disqualification of NC, all right, that's the employee, and any other IDHW officials, agents from treatment, okay, that's specific. Order issuing orders of conduct for the officials and or its agents to protect the defendant and her rights. So they want this court to order something that the IDHW is going to have to abide by. Okay, let me muddle with my paralegal brain on that one. See, oversight of defense counsel for all future treatment and the like provided by the state prosecution, and oversight of the defense counsel. I don't know if this court has the right to issue some of these orders that he's wanting. I don't know if that's even possible in a perfect world. It says, furthermore, defendant hereby objects to any ex parte and or sua sponte sealing of this matter. Wait, so then he also doesn't want anything sealed? Wait, is that because he thinks that there's some kind of conspiracy with the LDS and he wants this to blow up? Let's take everything that he's saying pretty much at face value. Let's say arguendo. We all know Lori's been committed. And he also had some attachments showing, her commission papers and stuff. So she's committed at this Idaho Department of Health and Welfare in order to make her better. So everybody's on the same page about her mental stability. And let's say arguendo that this employee really did come and for some reason had some agenda to make Lori want to watch this hearing with Chad Daybell and got it into her head that this was supposed to be her homework to call and get a different attorney, and that Lori was against it. She wants to keep Mark Means, and she wants to keep her current counsel. But for some reason, this person said, hey, no, reach out to the LDS church. And they gave her a phone number. And let's say that it was okay for her to call or whatever. She gets a hold of a phone and she makes this outbound call. And let's say that the secretary at the LDS legal department takes the call, doesn't or does know Vallow's name when she gives her full name, and the reason for her call before it's passed on to an attorney, that's not vetted properly, okay? Then the attorney gets it and knows who she is and then says, oh, I know everything about your case, and he brags to her about his curriculum vitae and all this stuff, and that she then makes admissions before he goes, oh, wait a minute, we're not in the same state. Let me get you a proper attorney, Ms. Vallow Daybell. And then he realizes this humongous error, though in theory, by the defense story, this was really something they set her up to do, to talk out of turn. So then the LDS attorney, realizing he did something wrong, calls Rob Wood's office, who then Rob Wood contacts the defense to try to fix this problem or to find out why Lori Vallow's reaching out. And they're trying to fix this problem, but yet they don't want this sealed, whatever she said. They don't want it sealed. Tell me that makes sense. Make it make sense, Jesus. I'm sorry I'm frustrated reading this, but frankly, this is, in my opinion, shenanigans. This is stuff that shouldn't be going on. If this happened at the Department of Health and Welfare, it shouldn't have happened. And the attorneys with any kind of ethics classes under their belt should know better than to take a call like this. To take an unvetted call from a high-profile client without that client's attorney on the line to hand her off from a facility, and you sit there and talk to her. It makes no sense. I know she's charming and has charmed the pants off many a man, but come on. Long story short, it seems to me like whatever happened was not planned. Was not planned on the part of the prosecutor's office. And it looks to me like they probably would like it sealed, but the defense doesn't want whatever it is spoken out sealed for whatever reason, and that makes no sense. If she said something, then it should be protected, because obviously she isn't well. And there's some kind of a ball that was dropped. In a way, is she so filled with machination that maybe she set this up to screw herself up? Again, he objects to this being sealed and he wants it resolved in a public forum. And I gotta ask, how does that benefit your unwell client? It's not right. If she is unwell and made statements against her own interest, out of her protected bubble, you should be wanting to protect her, not throw it onto the public arena. Stop it. and I was like, what is this mess? And I thought I'd react to it fresh without reading it ahead of time. So at least you get a fresh reaction. I don't know. What do you think? Please leave your comment in the comment section below. Comment below, do you think it's a conspiracy theory? Do you think it's a conspiracy fact? Do you think that maybe Lori's manipulating Mark Means? Do you think that Mark Means, in your opinion, really believes this? I think he probably does, because you're swearing on behalf of Lori Vallow. He says attorney advocate for the defendant. So, I mean, you're swearing to it. You don't want to swear to stuff that's shenanigans. I mean, so does he believe it, do you think? I mean, what's your opinion on this? How many drinks does the prosecution need when this kind of stuff comes across their desk? I mean, oh my Lord, I'm head up and I'm not even involved in it. So imagine how frustrated you would get. This case has got so much gravity to it, to have this kind of stuff going on. It's just unacceptable. In my opinion, this kind of stuff is shameful, and it's just not indicative of what the legal system's really like. But anyway, I hope you enjoyed this video. If you did, please hit the like, hit that subscribe bell, and without further ado, have an excellent day. Thanks. Bye.